Welcome to the deep dive. Okay, I want you to just picture this for a second. Think of a really luxurious apartment, high up, overlooking Brisbane. Sleek, modern, the kind of place that just breathes wealth, comfort.
Right.
But inside this beautiful space, there's this incredibly chilling scene. A woman, Maureen Boyce, she was quite a well-known socialite, she's dead, in her bed. And there's a kitchen knife sticking out of her abdomen right through the bed sheets.
It's a stark image.
It really is. And there's no sign of any struggle, nothing forced about the entry. The only other person confirmed to be in that apartment that night, her partner, Thomas Lang.
Just the two of them.
Exactly. Two people behind a locked door. And this death just screams out for answers. Was it, a deeply tragic private act of suicide?
Yeah.
Or was it murder?
And that's not a hypothetical, is it? That's the core question in a major Australian legal case, Lang v. the Queen, a case that went all the way to the High Court.
It did. And it wrestled with that fundamental problem. How do you figure out what happened behind that closed door when you have absolutely no direct evidence, no eyewitness, no confession?
Yeah, how can the prosecution prove, beyond reasonable doubt, that it wasn't suicide when their entire case is built on, connecting the dots, on circumstantial evidence alone?
And that's precisely our focus for this deep dive. We're drawing directly from the legal records here, court judgments, including that key high court decision, plus transcripts, news reports, all the documented facts.
Our goal really is to unpack everything, the events leading up to it, the people involved, because this is a human tragedy at its core, and of course the complicated legal path this case took.
And ultimately, what does Lang v. the Queen tell us about how justice works here in Australia, especially when proof relies entirely on inference, not on, seeing what happened?
It's a case that really throws a spotlight on the huge burden placed on juries and on the courts when they have to decide something so profound based only on circumstances. It makes you ask, what does beyond reasonable doubt truly mean without that smoking gun evidence?
Okay, let's start by getting to know the key people involved in this story, the individuals whose lives became entangled in this awful situation.
Right at the center, obviously, is Maureen Boyce, the deceased. The sources paint her as this Brisbane socialite, someone whose public life seemed, quite glamorous and connected.
But the reality was more complex.
Oh, absolutely. The court evidence revealed a much more complicated inner life. She had this long-standing marriage to Dr. Graham Boyce, though he lived up in Cairns, so it was somewhat distant. But she was also deeply involved in this rekindled, very intense affair with Thomas Lang.
And her mental health struggles became a really crucial part of the defense case, didn't they?
Hugely important. The evidence laid out a history of significant mental health challenges, specifically depression and bipolar disorder. This wasn't something new. She'd been hospitalized for these conditions before.
Including receiving ECT treatments.
Yes, electroconvulsive therapy. The sources mentioned she'd had ECT even in the months not long before her death, which just highlights how ongoing these struggles were for her. And critically, there was a documented history of suicidal thoughts, of ideation, and she'd made explicit threats previously.
Witnesses recounted things she'd said.
Yeah, things like, I wish I was dead, especially, it seems, during her depressive periods.
And wasn't there that specific, quite alarming incident involving a balcony?
Yes, that came out in evidence, too. Her son, Zachary, who's actually a doctor himself, he testified about an incident back in 2009. He said he had to physically intervene when she was right on the edge of a balcony, threatening to jump.
Wow.
And he specifically linked that kind of talk, threatening to jump off the balcony, only to times when she was severely depressed. But, the picture wasn't entirely bleak.
Right, it wasn't simple.
No. Source also described times when she seemed much better. People referred to her as the normal Maureen, sometimes even elevated or hypomanic. And just before she died, people said she seemed excited about selling her apartment and really genuinely happy about becoming a grandmother soon.
So a very complex picture of her mental state.
Definitely. Oh, and they also mentioned she suffered from arthritis, which sort of came up later in discussions about her physical ability to, inflict the kind of wound she had.
Okay, then there's Thomas Lang, the man ultimately convicted, the appellant in the legal case. A former doctor, correct?
That's right, a former doctor. The way the sources portray him, he seems to have been incredibly emotionally invested in Maureen, maybe even intensely so.
They had a long history.
Decades. They'd had a relationship much earlier in life.
Yeah.
It ended, apparently quite painfully for him, when she went back to Australia and married Graham Boyce. Lang described that separation as devastating.
But they reconnected later.
Yes. years later. And this rekindled relationship, he described it in really strong terms. She was the love of his life, his ever-loving and eternal soulmate. They apparently had real plans, marriage, her moving to New Zealand to be with him.
But he had his own issues too, didn't he, around that time?
Seems so. The sources mentioned that Maureen herself had noticed Lang struggling just before her death. She'd apparently commented on his heavy drinking and said he seemed severely depressed himself. So, yeah, both of them were dealing with their own significant personal challenges.
And Dr. Graham Boyce, Maureen's husband. He wasn't there that night, but he provides important context.
He does. He was a GP based up in Cairns. The evidence showed he knew all about Maureen's relationship with Lang and her plans. But despite the complicated nature of their marriage, he was still involved in her life, particularly her care.
He'd accompanied her for treatments?
Yes. Sources say he'd come down to Brisbane with her for some of her mental health treatments. And crucially, he spoke to Maureen on the phone on the evening of October 21st, just hours before she died.
What was that conversation about?
Just practical stuff, apparently. The valuation for her apartment she was selling. But his evidence was that she sounded quite happy during the call and very assertive. She was giving him clear instructions about getting the valuation details to her the next morning.
Which seems quite at odds with someone in deep suicidal despair at that exact moment.
That was certainly the implication the prosecution wanted the jury to draw. The sources also mentioned he himself was undergoing some medical treatment, which was partly why he'd been spending time in Brisbane with Maureen periodically.
And their children, Maureen and Graham's children.
They also feature in this narrative. Their son, Zachary, the doctor we mentioned, he actually lived in the same apartment building as his mother.
Right, so his evidence about that 2009 balcony incident was very direct.
Very direct, and provided that crucial context about her past suicidal threats being linked to severe depression. He also gave evidence about her general depressive symptoms over time and commented on her technical skills versus her limitations from arthritis.
And their daughter.
Angelique Panisi. She was married, expecting her first child, the grandchild Maureen was apparently so excited about. But adding another layer of difficulty to Maureen's life just then, the sources reveal Angelique and Maureen had a major falling out shortly before Maureen died.
Serious conflict.
Very serious. Angelique had sent her mother this incredibly harsh text message. It was presented in court. Things like, "You have ruined our family, you slut," and saying she didn't want Maureen to meet the baby.
Goodness. That must have been devastating for Maureen.
You'd have to assume so. These complex family dynamics certainly paint a picture of Maureen being under considerable emotional stress from multiple directions in those final days.
Okay, and then there's the man the prosecution pointed to as the trigger for the whole alleged incident. Mr. McAlpine, known as Kenneth.
Yes, Kenneth.
Yeah.
Described as a past lover of Maureen's. And the text messages between them became absolutely pivotal to the prosecution's case theory. Because the prosecution alleged that Thomas Lang discovered these texts late on the night of October 21st. And that discovery is what sent him into a rage. The specific texts were viewed on Maureen's phone just before midnight.
Do we know what they said?
One key text from Kenneth that was viewed read something like, "I truly think we would do each other a world of good to catch up. I miss you heaps, XOX. And there were replies from Maureen too, like, "Love ya, Maureen," and her asking when he was planning to come to Brisbane.
And the prosecution argued Lang saw these and
interpreted them as Maureen continuing or rekindling things with Kenneth. They argued Lang felt profoundly betrayed, especially after, pinning all his hopes on their future together. This discovery, they contended, was the catalyst for a jealous rage that led him to stab her.
Right. And then rounding out the key figures, we have the expert witnesses. Their testimony was critical.
Absolutely indispensable in a case like this. Dr. Ong, the forensic pathologist, was central. Hugely controversial, but central. His role was to examine the scene, conduct the autopsy, determine the cause of death.
And his opinion was quite definitive, wasn't it?
Well, he gave an opinion that the fatal wound was more likely inflicted by a second person than by herself.
Yeah.
That became a cornerstone for the Crown.
What did he base that on?
He said it was based on his, decades of experience looking at stab wounds, suicides, homicides, plus reviewing the literature and applying his logical sense of what happened, as he put it.
And what specifically about the wound itself led him to that conclusion?
He focused on a few things. It was a single entry wound on the skin, but inside the body, there were multiple tracks, which means the knife wasn't just pushed in once. It was partially pulled out and then pushed back in, maybe rotated, all through that same entry point.
Okay.
He also mentioned the lack of hesitation wounds, those smaller tentative cuts sometimes seen in suicides. He found the combination of features odd for a self-inflicted wound, unusual.
But he couldn't completely rule out suicide.
No, and that was a crucial concession under cross-examination. He admitted he couldn't definitively exclude it. He also conceded he didn't have Maureen's full, detailed mental health history when he first formed his opinion. And he made this comment, which the defense really seized on, that he didn't think someone killing themselves would take the trouble to rotate the blade.
Which the defense argued wasn't really expert forensic opinion.
Exactly. They argued it was more like a personal, subjective view on how someone might behave, not grounded in pathology.
And the other key expert was Dr. Mark Spellman, the psychiatrist.
Yes, Dr. Spellman.
Oh.
Called by the Crown. He testified about Maureen's complex mental health history, the bipolar disorder, the borderline personality disorder diagnosis, the ECT, the long history of suicidal thoughts.
Had he seen her recently?
Yes, very recently. He'd actually assessed her just 2 days before she died, and his assessment then was that she seemed elevated, not obviously depressed. Though he did note she'd mentioned a plan to basically get Lang out of her life without telling him first, which concerned him.
So his evidence was interpreted differently by each side.
Completely. The defense pointed to the long history, arguing suicidal thoughts weren't only linked to deep depression for her, they could emerge when she was upset or in turmoil. The prosecution, however, really emphasized that recent assessment, showing she wasn't deeply depressed right before her death, trying to argue her death didn't fit the typical pattern of suicide linked to a depressive episode.
Right. So we have this incredibly complex web of people, histories, relationships, mental states, all converging on that one night. Let's walk through the events leading up to the discovery. What happened in the days just before?
Well, the picture painted by the sources is of Maureen being pretty active, actually. In the days right before October 22nd, she'd been traveling, seeing friends. She was apparently talking excitedly about becoming a grandmother, about getting the apartment sale finalized.
She was communicating with both Lang and her husband.
Yeah, definitely. Texts exchanged with Lang after she got back from a trip to New Zealand included her saying, "Miss you already, darling," and him replying with extreme enthusiasm, "I love you, darling." She also apparently texted about wanting him back in NZ ASAP.
And she was still dealing with practicalities with her husband.
Yes, that phone call with Maureen Boyce on the evening of the 21st, the one where he said she sounded quite happy and very assertive about the apartment valuation, that was significant.
What about that text where she mentioned feeling depressed again?
There was a text like that to her husband a few days earlier, yes. But the context suggested, or at least the prosecution argued, it might have been more about seeking attention or contact from him, because her actual activities afterwards didn't seem to line up with a major depressive crash. It became a point of contention. Was she genuinely in a suicidal state then?
Okay, so fast forward to the evening of October 21st itself. They went out.
Maureen and Lang went out for dinner. Later that night, back at the apartment, an argument started. Now, why it started was disputed. The prosecution suggested Maureen found something on Lang's phone. Maybe texts to another woman, maybe internet searches indicating he might be cheating. Lang's story, though, was that the argument was because she was accusing him of seeing someone else.
And during this argument, she mentioned Kenneth.
She did. According to Lang's account of the argument, Maureen said things like, "I'm going to hook back up again with that Kenneth guy," and that she'd already contacted Kenneth and he was coming to fix things. So Kenneth was explicitly brought into their fight.
And then the incident with her phone supposedly being thrown off the balcony.
Yes, according to Lang's initial statement to police, sometime between about 9:00 and 9:45 p.m., Maureen locked his phone with the PA and then threw her own phone off the balcony in anger.
That wasn't true.
Well, the forensic evidence from Maureen's phone directly contradicted that timeline. Data recovered from the phone showed it was unlocked, using its PIN at 11:56 p.m. that same night. And between 11:58 p.m. and 12:03 a.m., someone used the phone to view those very text messages exchanged between Maureen and Kenneth.
So the phone definitely wasn't off the balcony at midnight, and someone was looking at those specific texts.
Precisely. That discrepancy became absolutely massive for the prosecution. It blew a huge hole in Lang's initial account.
And they argued it showed consciousness of guilt.
That was their argument, that he lied about the phone to cover up the facts that he had found and viewed those texts, which they said triggered the murder. According to Lang's version, after the argument and the supposed phone throwing, Maureen just wanted to be left alone, went to bed, and he slept in a different room.
Which brings us to the morning of the 22nd.
At 5:32 a.m., Thomas Lang makes that 000 call. He calls from the landline phone, which was right there beside Maureen's bed.
And what did he say to the operator?
He said he'd just woken up, found his fiancée dead, knife in her abdomen. He mentioned her hand was just in contact with the knife handle, said she'd been distraught the night before, and repeated that he'd slipped in another room. He also identified himself as a doctor.
Police and paramedics arrived soon after.
Around 6 a.m.
And what did they find at the scene? Take us there.
They found Maureen on the bed. Large kitchen knife sticking out of her upper abdomen, blade having gone through the top sheet. There was a significant amount of blood pooled on the bedding around the wound itself.
Blood on her hands.
Yes, on her left hand. But importantly, not on her right hand, which was found tucked under a pillow.
Any other blood? Signs of a struggle? Clean up.
Only a couple of small drops of blood found on the carpet beside the bed. Crucially, investigators found no signs of any attempt to clean up blood in the apartment, and absolutely no evidence of forced entry, confirming it was just Lang and Maureen inside overnight. Security confirmed no one else accessed their floor.
What about the forensic analysis of the knife itself? This seems critical.
It was, and the lack of certain evidence was just as debated as the evidence they did find. So no usable fingerprints were recovered from the knife handle at all.
None.
None. And the only DNA found on the handle itself matched Maureen Boyce.
No trace of Thomas Lang on the knife.
Not on the handle, no. His DNA wasn't found anywhere else on Maureen's body either, except for on her breasts, which both sides accepted could easily be explained by their intimate relationship or contact earlier.
And no injuries suggesting a fight.
None. No defensive wounds on Maureen, no injuries on Lang, consistent with him having been in a struggle.
So the defense must have pointed strongly to this lack of physical evidence linking Lang to the stabbing.
Oh, absolutely. They argued it fundamentally weakened the Crown's case. How could they prove he did it if his prints and DNA weren't on the weapon?
How did the prosecution respond to that?
They argued that the absence of DNA or prints isn't conclusive proof of innocence. Not every touch leaves a perfect print, especially on certain surfaces, and blood could theoretically be wiped even if they didn't find obvious signs of wiping. The Crown did concede, later in the appeals, that the lack of Lang's DNA where Maureen's blood was present did weaken their case somewhat, but they argued it wasn't fatal when weighed against everything else.
Let's revisit Dr. Ong's medical evidence about the wound itself, the multiple internal tracks.
Yes, that was a major focus. That single entry point, but multiple internal paths, meaning the knife was manipulated inside the body, partially withdrawn, replunged, possibly rotated.
And this wasn't instantly fatal.
No. Dr. Ong's opinion was death resulted from slow blood loss. He estimated Maureen would have been conscious for somewhere between 5 and 15 minutes after the stabbing occurred.
Meaning she could have moved, resisted, called out.
Potentially, yes. She would have been capable of movement and resistance during that time. Her blood alcohol was relatively low, 0.049, and the prescription drugs in her system, Valium and others, were at therapeutic or subtherapeutic levels.
So not necessarily enough to incapacitate her.
Dr. Ong initially suggested probably not enough to prevent resistance, though he did acknowledge that individual reactions to drugs and alcohol can vary and they can interact. There was also some blood pattern evidence suggesting she might have initially been in a sort of crouching position before ending up lying on her back. The estimated time of death was put somewhere between 1.45 a.m. and 3.45 a.m.
Okay, so all this evidence, the scene, the timeline, the forensics, or lack thereof, the medical details, the personal histories, it all had to be pieced together. And it boiled down to one fundamental conflict.
Exactly. Suicide or murder. That was it. It was accepted by everyone, at trial and on appeal, that those were the only two possibilities. No third party, no accident, which put a very specific burden on the prosecution.
They had to disprove suicide beyond reasonable doubt.
Precisely. To get a murder conviction against Lang, they had to convince the jury that suicide was not a reasonable possibility on the evidence. And their entire case, as we've said, was circumstantial, just inferences drawn from these facts.
So can you summarize the prosecution's theory of how it happened, based on their interpretation of those circumstances?
Okay, the Crown's narrative was this. Thomas Lang discovers Maureen is still in contact with, or possibly restarting something with, her ex-lover, Kenneth. He likely finds this out by looking at those texts on her phone late that night, the text he later lied about being thrown off the balcony.
Triggering the motive?
Yes, triggering intense, jealous rage. He felt utterly betrayed, having, as he saw it, hinged everything on her and their planned future. This betrayal possibly fueled by his own depression and the alcohol he'd consumed, causes him to snap.
And the act itself.
They alleged he stabbed her, likely while she was asleep or maybe very drowsy or groggy from her medication, alcohol, fatigue. That would explain the lack of any struggle or defensive wounds.
And the lie about the phone.
Critical. They argued it was a significant lie showing consciousness of guilt for the murder itself. Why else tell such a specific, easily disprovable lie about the timing? And they pointed to Dr. Ong's evidence, the multiple tracks, the rotation of the knife as being highly inconsistent with typical suicide methods, suggesting instead a deliberate, perhaps angry attack by another person. They also argued that if she had been awake and able, she would have fought back, given the wound wasn't instantly disabling.
Okay, and the defense. How did they construct this suicide narrative from the same facts?
The defense focused heavily on Maureen's documented mental health history. They argue that yes, she had good periods, but her underlying conditions, bipolar, borderline personality disorder, and her extensive history of suicidal ideation and threats, including that specific, serious balcony incident, showed she was tragically vulnerable.
So they argued she took her own life in a moment of despair.
Exactly. Perhaps triggered by the argument that night, her complex feelings about her relationships, or just the culmination of her ongoing struggles. They argued the scene was actually more consistent with suicide. The knife position, the blood mainly localized around the wound in her left hand, plausibly the hand she used, the complete lack of defensive wounds or any sign of a struggle on Lang, and the fact she didn't use the phone right beside her bed to call for help.
What about the unusual nature of the wound that Dr. Ong highlighted?
They challenged its significance. They stressed that Dr. Ong admitted he couldn't exclude suicide. They argued that while he found the features odd, suicides don't always follow neat patterns, especially given Maureen's complex mental state, which Dr. Ong didn't fully know initially. Unexpected things happen in suicides.
And Lang's lie about the phone.
They offered alternative explanations: panic, shock, confusion in the immediate aftermath. Or maybe just wanting to hide the embarrassing, disgraceful fact that he had this huge row with his fiancée, culminating in a phone, potentially being thrown bad behavior, maybe, but not necessarily proof of murder. They also argued the drug and alcohol levels weren't high enough to guarantee she couldn't have resisted if attacked, making the lack of resistance potentially point away from homicide.
Wow. Two completely different stories built from the same ambiguous pieces. The jury had an incredibly difficult task. This brings us to the legal journey itself.
A long journey. As mentioned, Thomas Lang was actually tried twice. We're focusing on the retrial. At that retrial, the Crown was represented by Mr. Fuller, QC. The jury heard all this evidence we've discussed, the histories, the events, the forensics, the experts, the arguments about the lie.
And the verdict at the retrial?
Guilty of murder. Thomas Lang was sentenced to life imprisonment. The core issue right through the trial was, could the Crown exclude suicide beyond reasonable doubt?
And Lang appealed this conviction.
He did, straight to the Queensland Court of Appeal, the QCA. His legal team lodged the appeal. They raised two main arguments, or grounds.
What were they?
First, the classic unreasonable verdict ground. They argued that, looking at all the evidence presented at trial, the jury's guilty verdict was unreasonable or couldn't be supported. Basically, they contended that a reasonable possibility of suicide still remained, meaning the prosecution hadn't met its burden of proof.
Okay, and the second ground?
This focused squarely on Dr. Ong's evidence. They argued a miscarriage of justice happened because the trial judge wrongly allowed Dr. Ong to give his opinion that the wound was more likely inflicted by another person than self-inflicted. They challenged the very admissibility of that crucial opinion.
Who heard this appeal at the QCA?
It was heard by three senior judges, Justice McMurdo, Justice Mullins, and Justice Brown. They were referred to as Justices of Appeal, or JJA.
And their decision?
They dismissed the appeal. They upheld the murder conviction.
How did they deal with those two major arguments from Lang's team?
Okay, on the unreasonable verdict point, the QCA acknowledged they had to make their own independent assessment of the trial evidence, following the precedent set by the High Court in M v. the Queen. Justice Mullins gave the main judgment, and she concluded that, yes, based on that independent review, it was open to the jury to be satisfied of Lang's guilt beyond reasonable doubt.
So they felt the evidence was strong enough?
They found the combination of evidence was strong enough. They specifically mentioned the unusual wound features, the potential motive linked to the Kenneth texts, and what they termed Lang's significant lie about the phone. They felt this cumulative picture was capable of excluding suicide beyond reasonable doubt. They did note Dr. Ong couldn't exclude suicide, but said the jury could still give weight to his findings about the wound's odd characteristics. They also considered the lack of struggle, suggesting it could be explained by drugs or sleep, but also that the evidence supported an inference that if she could have resisted, she would have, making the absence of resistance potentially support the Crown case.
And the challenge to Dr. Ong's expert opinion being admissible.
The QCA backed the trial judge's decision there, too. They rejected the argument that Dr. Ong's opinion was just personal speculation. They found it was based on his specialized knowledge and extensive experience as a forensic pathologist dealing with stab wounds. His views on the significance of the wound features, they decided, stemmed from that expertise.
So any issues with his reasoning went to weight, not admissibility.
That was their conclusion. They felt his evidence met the necessary threshold for expert opinion based on a reliable body of knowledge, forensic pathology, and it was up to the jury to decide how much weight to give it, considering any weaknesses brought out in cross-examination.
So a setback for Lang at the Court of Appeal, but his legal team pushed further.
They did. The next step was applying for special leave to appeal to the highest court in Australia, the High Court. You don't have an automatic right to appeal there. You have to persuade the High Court to grant permission.
Who argued for and against leave being granted?
Appearing for Thomas Lang, seeking leave, were Ms. R.M. O'Gorman, KC, that's King's Counsel, and Mr. D.M. Caruana, instructed by Fisher Door lawyers. Arguing against leave for the Crown, the respondent, the Queen, was Mr. M.A. Green, instructed by the Queensland DPP's office.
What did Lang's team argue to convince the High Court this case warranted their attention? It's rare for circumstantial cases like this to get leave, isn't it?
It is relatively rare. They essentially reframed their QCA arguments. Firstly, they reiterated the unreasonable verdict claim, arguing there was a significant possibility an innocent person stood convicted. They criticized the QCA's review, saying it didn't properly engage with the whole evidence and the real possibility of suicide, perhaps just finding a possible pathway to guilt rather than rigorously applying the Envy the Queen test themselves. Secondly, they argued the admissibility of Dr. Ong's opinion raised a crucial point of law of general public importance. Where exactly is the line between permissible expert opinion on cause of death and subjective guesswork, especially from forensic pathologists? They worried it gave an unwarranted appearance of science to what might be personal belief.
And the High Court decided.
They granted special leave. This meant the High Court justices felt the issues, particularly around appellate review of circumstantial verdicts and the basis for expert opinion, were significant enough for the full court to consider.
So the final stage. The appeal to the High Court of Australia itself. Lange the Queen, 2023, HCA 29.
That's the one. The appeal was heard by a bench of High Court justices. We know Justices Gordon, Edelman, and Gleeson were involved at the leave stage, and the final judgment was unanimous from the full bench hearing the appeal. Ruth O'Gorman, KC, and Daniel Caruana filed the written arguments for Lang. The Crown, as respondent, filed submissions in reply, likely prepared by Mr. Green's team.
What were the core arguments Lang's team put to the High Court justices?
They really doubled down on the critique of the QCA's application of the Envy the Queen test for unreasonable verdicts. They argued the QCA failed in its duty to conduct a truly independent assessment and form its own judgment about whether guilt was the only rational inference available from all the evidence. They pointed to the major weaknesses: no forensic link, no struggle, arguing the QCA hadn't given the sufficient weight when deciding if suicide could be excluded. They argued the evidence about Maureen's state suggested she could have resisted, making the lack of struggle even more problematic for the Crown. And the lie about the phone, they maintained, wasn't necessarily proof of murder guilt. Other explanations like panic remained plausible.
And how did the Crown defend the conviction at this final hurdle?
The Crown defended the QCA's approach. They argued the QCA did review the whole evidence properly and correctly found the cumulative weight of the circumstances. The wound, the motive, the lie, the lack of struggle potentially explained by her condition or surprise was enough for a rational jury to rule out suicide beyond reasonable doubt. They stood by Dr. Ong's evidence as admissible expert opinion grounded in his specialized knowledge, with any perceived flaws going only to the weight the jury assigned it. They acknowledged the lack of DNA weakened their case, but argued it wasn't fatal given the strength of the other circumstantial threads combined.
So after considering all this, the High Court delivered its unanimous verdict on the appeal. What was it?
The High Court unanimously dismissed Thomas Lang's appeal. They affirmed the decisions below, meaning his murder conviction stands.
How did they justify that, especially given the circumstantial nature and the admitted complexities?
Their reasoning is really instructive. On the unreasonable verdict ground, they strongly re-emphasized the MV the Queen principles. They stressed just how high the bar is for overturning a jury verdict on this basis. The appeal court's job isn't to retry the case or substitute its own view or doubts.
It's an objective test.
Purely objective. Was it open to a rational jury, based on the total evidence presented, to be satisfied of guilt beyond reasonable doubt?
And this is where that remarkable honesty from the judges came in.
Yes, it's quite striking. Justices Gordon and Edelman, in their reasons, explicitly wrote that they candidly admitted they personally wrestled with doubts about the case. It's rare to see that level of personal reflection stated so openly. But they immediately followed by saying that, despite those personal doubts, their legal duty was to apply the objective test.
In applying that test,
They found that when you looked at the evidence cumulatively, the wound characteristics, the powerful motive, the significant lie about the phone, all taken together, it was sufficient for a rational jury to exclude suicide beyond reasonable doubt. Even if individual pieces could be explained away, the combination allowed the inference of guilt. They deferred to the jury's role as the constitutional finder of fact.
and the challenge to Dr. Ong's expert evidence admissibility.
The High Court upheld its admission too. They went back to key cases like Makita and Dasreef on expert evidence needing to be based on specialized knowledge. But they noted that how much an expert needs to explicitly detail their reasoning can vary. An experienced specialist might rely heavily on their accumulated knowledge.
Oh, so Dr. Ong's opinion, even with subjective elements, was seen as rooted in his expertise.
Yes. They found his opinion on the oddness of the wound for suicide, despite defense arguments about subjectivity, was fundamentally based on his vast experience as a forensic pathologist comparing suicide and homicide wounds. Even if he didn't know every detail of Maureen's history or hadn't seen this exact wound before, his opinion had a sufficient basis in his specialized knowledge to be admissible. Any weaknesses went to wait for the jury, not admissibility. They affirmed the underlying field, forensic pathology, is a reliable body of knowledge.
So the High Court essentially said, circumstantial case, yes. Difficult, yes. But legally sufficient for a jury to convict if the cumulative evidence allows them to exclude other possibilities beyond reasonable doubt.
That's the essence of it. Lang confirms that a strong, well-constructed circumstantial case can meet the high standard of proof in criminal law, and appellate courts will respect a jury's finding if it's rationally supported by the totality of that evidence.
How then has this specific case, Lang v. the Queen, actually impacted legal practice here in Australia? What's its legacy?
It has several important implications. Firstly, regarding circumstantial evidence cases and unreasonable verdict appeals, Lang is a very strong modern statement from the High Court about the strength such cases can have.
It makes those appeals harder for defendants.
It certainly reinforces the high bar. It doesn't change the MV the Queen test, but it's a powerful illustration of how appellate courts apply it objectively, deferring to the jury's role, even amid personal judicial doubt.
Yeah.
You can bet prosecutors are citing Lang regularly now to resist arguments that a circumstantial conviction was unreasonable.
And the High Court's honesty about their own doubts really emphasizes that disciplined legal approach.
It really does. It shows that appellate review isn't about whether the judges agree with the verdict, but whether the verdict was a rational outcome available on the evidence presented to the jury.
What about the handling of expert evidence going forward?
Lang provides significant clarification there too, particularly for fields like forensic pathology. By upholding Dr. Ong's evidence, even with its inferential leaps based on experience, the High Court arguably gives trial judges more confidence in admitting expert opinions that aren't purely objective measurement, but involve interpretation based on specialized knowledge and experience.
Even opinions on the ultimate issue, like homicide versus suicide.
Potentially, yes, as long as the opinion is demonstrably rooted in the expert's field and specialized knowledge derived from training or experience, as required by Section 79 of the Evidence Acts in cases like Makita. Lang reinforces that once that admissibility threshold is met, assessing the reliability and weight of that opinion is firmly the jury's job.
And it offers that unique insight into the appellate mindset.
Absolutely. That candid admission of personal struggle, juxtaposed with the unanimous legal finding, really highlights the discipline separation required. Reviewing the rationality of the jury's decision, not reweighing the evidence based on personal feelings. It underscores the primacy of the jury in our system for resolving factual disputes, even the most harrowing ones.
So we followed this incredibly sad story from that apartment in Brisbane through the complex lives involved, The stark choice between suicide and murder, and its entire journey through the courts, right up to the High Court's final unanimous word.
A final word that affirmed the conviction, finding that even without direct proof, the web of circumstantial evidence was legally strong enough for a rational jury to be convinced beyond reasonable doubt that Thomas Lang murdered Maureen Boyce, and that suicide was not a reasonable possibility.
And throughout all this intricate legal argument, we have to remember the devastating human reality. Maureen Boyce lost her life. Thomas Lang is imprisoned for life, and the families on all sides continue to live with the consequences.
It's a stark reminder of the immense stakes involved and the profound difficulty in finding definitive truth sometimes.
In cases built solely on connecting the dots where deeply personal lives and the limits of forensic science collide, the ultimate question of truth rests with the jury. And as this case shows, even the highest courts, while wrestling with their own doubts about such complex facts, will respect that decision if the evidence, taken as a whole, allows for that conclusion. It leaves us asking, what does beyond reasonable doubt truly mean when the only witnesses were the victim and the accused?